Okay, I did that really fast, and that's why the sound is cut out, because I was getting a phone call because I'm trying to do 17 things at once. But don't, just keep watching it. You can read the subtitles and it comes back on. I promise you didn't miss anything major. But I have now had a chance to sit down and think about it for 5 seconds. That was literally me running and recording 10 minutes right after I read it. So I didn't have much time for introspection or thought beyond understanding what the ruling was. And I'm starting to do that now, which I'm assuming will continue over the course of the next couple of days. So here's my sort of next level thoughts. A lot of the claims that Baldoni and Wayfarer brought were very big swings. They were big swings and they missed. Civil extortion was a very big swing. There's just, the basis for it in California law is minimal at best. That was a very big swing. Suing the New York Times was a gigantic swing, and they missed. I mean, I think most of us have been saying since the beginning, lawyers, that no judge is going to allow a defamation claim against the New York Times to go forward in New York. Media is pretty well insulated. So that was also a big swing. And defamation claims against or about public figures where you have to prove actual malice are always a big swing. They took a bunch of big swings and they missed. And, you know, that's the risk of filing litigation like this. Is at the time, I think it was what they wanted from a PR standpoint. They wanted to show that they were fighting back, that they weren't just defending themselves, but that they were being affirmatively on the offense. And factually, you know, they got a bunch of information out there for all of us to see, but legally it just wasn't enough. So, you know, I think there's always clarity with time. I think one of the things we also learned is that the legal advice that Lively got, wherever she got it from, that if she wanted to have this stuff reported on by the New York Times, it needed to be inside of some sort of legal document or legal complaint or associated with a legal proceeding, was very sound advice. Because the fact that it came through that lens protected every single step of that, whether you agree with that from a policy standpoint or not. It allowed all of those protections to run with the information. And everything else that the Wayfarer folks were trying to say, well, this must have happened, they just didn't have any information about sufficient for them to survive a dismissal. With regard to the standard, and I knew this was going to be a big deal. I was anticipating the New York Times would get dismissed, and I was anticipating having to explain this to people, but now I get to explain it with everybody. The standard for dismissal under 12b-6 is failure to state a claim, right? It is failure to state a claim upon which relief can be granted. So it's saying, based on what you've pled in your complaint, even taking that in the light most favorable to you, even assuming everything in your complaint is true, you still cannot meet the legal elements and requirements of the claims that you have asserted. That's what dismissal is, and that's what this judge found under 12b-6. And that is a win for the Lively people, no matter how you shake it out. And anyone who tells you that it's somehow a win for Baldoni, whatever, it's a win for Lively. But it is also not the same thing as a finding that Baldoni's case was frivolous, baseless, bogus, that kind of thing. Those are different. So for example, you may remember that Lively and Reynolds had filed Rule 11 motions, sanctions motions, on the same basis for which they filed their motions to dismiss, saying this is so bad that it goes beyond just being something that the court should dismiss. They should actually sanction the Wayfarer parties for bringing it. And the judge did not do that. He did not raise that. He did not say, not only am I dismissing these claims, I'm finding that they're completely without basis in law or fact, they're frivolous and they never should have been brought, and I'm going to sanction the Wayfarer parties for doing that. He did not say that in this order. Now, if the Lively and Reynolds parties ask him to do that now, which wouldn't surprise me, he could look at that issue, but I would be very surprised if he did that. It's just not the same thing. Saying this can't possibly translate into a legal claim is not the same thing as saying this was a waste of everybody's time and resources. You abused the process, you abused the court. So the dismissals with prejudice, which is everything except those two claims, are appealable. Generally speaking, only final orders are appealable, meaning things that end that issue in the case at the trial court level. There's some interlocutory orders that you can appeal, which are things in the middle. So dismissal with prejudice is appealable, so they could appeal some of this stuff up to the Second Circuit Court of Appeals. I don't know that they will do that. That's a strategic discussion they have to have. You'd have to find some legal argument that you think was worth it, where you think there was particular error, and try to appeal that up to the Second Circuit. I think there's probably a 90% chance that Baldoni won't do that. If for no other reason, then it will delay everything. It'll delay a lot. And part of the reason why I think they didn't file motions to dismiss Lively's claims is because it would have caused delay. So I'd be surprised if they do that. But they have to make that strategic decision about, is it worth it to do that? Do we have a chance we're actually going to get a ruling that we want? Is it really going to reverse everything, or do we just move it along? Reynolds and Lively, with those two claims that are left, and involves those two, they have until June 23rd. Wayfair has until June 23rd to file amended claims on those two issues, and then we will see if those can pass muster or if those get dismissed too. So regardless of what happens, Wayfair now has to put together those amended complaints. They could just say no. They could say, forget it. We're just going to be defendants. We're not going to be plaintiffs. We're done with this. They could do that. Of course, there are all sorts of strategic decisions why you would or wouldn't. One of the reasons that you might like to have some of those claims open, particularly the one that relates to Blake's activity and conduct on the film set, is that it keeps that issue in discovery so that you continue to discover information about that. Because remember, the scope of discovery is defined by what is in the active claims that are being tried. So with a bunch of these claims getting pulled out, that can really narrow the scope of discovery. So we'll see what Wayfair decides to do there. They're going to probably have a fees hearing. The judge said at the end, so usually when you get what you asked for, right, the motions to dismiss are granted. They had asked, and by the way, as part of our relief in getting our motions granted, we want our attorney's fees paid for. And of course, under 47.1, they wanted, treble damages and all that kind of stuff. I don't think they're going to get that. He basically said as much because he said, I did not make a ruling under 47.1. So the damages for that would probably not be included. But he did say, I'm denying the motions for fees without prejudice if you want to bring them up again. So he's basically saying, I'm not just going to give them to you off the cuff. If you want to brief it and make the arguments to me as to why you deserve those specifically in this case, I'll listen. But I'm not going to do it on my own. So we'll see what they do there. Again, knowing the Lively folks and their lawyers and the way they like to litigate, I presume they're going to go ahead and do that. So that'll be a whole nother level of briefing, and then there'll be a bunch of argument back and forth about what the judge did or didn't do. He really thought this was frivolous. No, he didn't. He just said this, and then they'll argue, and then the judge will say, this is what I said, and he'll decide. And finally, at least for this one, I'm just going to keep posting all night as I think of things. This is just proof that you never know what is going on. Like, they're filing all these motions to compel, and they're filing these sanctions motions, and all this shit is happening with Taylor Swift. And unbeknownst to us, during all of that time, the judge is, with his clerks, drafting a motion to dismiss Baldoni's entire case. So as I said at the beginning, and as I will continue to say, the thing about litigation is you just never know what's going to happen next. I don't think anybody anticipated he would do this. That doesn't mean it's wrong. The more I read it, the more I think it's the right decision. But you just never know. And people who say, I read a document on the internet, so I know what the judge is going to do. They don't.